Hello, everyone. Welcome to another episode where we discuss conveyancing and the process of conveyancing. Now, first things that we need to understand that conveyancing is a step-by-step process. If you don't take it step by step, you might just confuse yourselves or confuse the entire transactions of people involved in this transaction. Now, what steps are included within conveyancing? We won't go into much detail. We just discuss the steps and how do you go by those steps. Obviously, in the next videos, we discuss each step separately. You can go to my YouTube channel, and I have discussed how, as a conveyancer, should you take the process of conveyancing from start to finish. Now, for a layman, what I'd say is when you basically go to buy a property, it's not a one-day process. Sure, you may get to be interested in the property that you want to buy, but it's subject to contract. Now, what does subject to contract mean? Means that is where the entire process lies. Now, first off, you go into the market, you look for a property, you find a property that is suitable for your needs. You instruct an estate agent, or you privately approach the seller and you say, well, I want to buy this property, and the seller accepts, or the estate agent accepts on their behalf. You view the property, you do everything. After that, you have to instruct solicitors, surveyors, and if you get in a mortgage, your mortgage brokers. Now, before instructing solicitors, you need to have a mortgage in place, or a mortgage in principle in place, basically an offer that you would have gone with, because essentially what you have to do next is dependent on who your lender is. Some law firms, some solicitors, or some conveyancing firms, they may not be on the panel of the lender that you choose to go ahead with. So you really need to first figure out your lender, who your lender is going to be, whether or not he accepts, he provides you with a mortgage offer or a agreement in principle, an AIP. Once that's done, then you know that you've got an AIP in place. Then you can go to a solicitor's firm. Now, once you go to a solicitor's firm, they would send you instruction documents, and they let you know of their fee, what their fee are, what their legal fee is, what are disbursements. Now, some people get confused as to what disbursements mean. Now, disbursements are third-party government fee or third-party fee that we do not have any interest. For example, it can be ordering a searches pack, or land registry fee, or ID checks, in some cases. So, after you've instructed solicitors and they've sent you the documents for you to sign, which is basically the instruction documents, that is basically your agreement with the solicitor, the terms of service and the terms of business for that service that you're availing from them, which is in this situation a purchase. So you would expect it to be a purchase instruction rather than a sale instruction, or rather than a remortgage instruction. Obviously, if you're selling another property, that would be another matter altogether. You can't expect solicitors to be instructed on two different matters in the fee of one. So get these questions quite a lot. Like, I mean, so if I'm purchasing a property, right, we've instructed you, you've sent your client care documents to us as clients, but now I want to instruct you as solicitors for my sale as well, which is a linked transaction. And when I say to them that you have to either go back to the referrer that has referred you to us, or you'd have to get in touch with our new business team. It means that we have an agreement in place. If it's a referrer, if it's a broker, we have an agreement in place that you can't come to us directly, and you have to go to the referrer first, instruct them, and they instruct us on your new instructions of the sale of your property. And similarly, if you have a separate instruction, if there is no referrer involved, we'd refer you to our new business team, who then provide you with the documents and a separate matter reference for the sale of your property. Instructions differ for a purchase, a sale, remortgage, transfer of equity, and other matters of conveyancing as well. Right. So once you have sent signed documents to us, we expect you to send monies on account to us. Now, what do we mean by that? When we are instructed, you need to confirm that we're instructed by sending £400 or £300, or if it's a sale, £100 to our client account, which we may have attached in an email. This is to confirm instructions. We hold these monies for you for any third-party charges, as I explained, which are government fees, which are third-party fee that we have no interest in. Once that's done, and obviously that forms part of the quote that we have provided you at the very outset of the transaction. So it's not an additional fee. Once that is done, once you've transferred the requisite amount as we would have requested in one of our documents or in an email, that is when we're actually instructed by yourselves. That is when, after that, we get in touch with the estate agents, or if it's a private purchase, if it's a private sale, we get in touch with the seller's solicitors. Once the seller's solicitors confirm instructions, and once we confirm instructions to them, that is a communication between solicitors who would say, we're instructed on so-and-so property by so-and-so XYZ, Mr. XYZ, or Mrs. XYZ, or Mr. and Mrs. XYZ. And we adhere, we confirm that we adopt the code of conveyancing. We have a code of conveyancing. It's a protocol that conveyancers or solicitors have to adopt in the process of conveyancing, because that code gives us a pattern to work on, so that we're not elongating a transaction for an unnecessary reason. It's a step-by-step code and tells us if there's something that we need to raise or some things that we can't raise. Now, once those instructions are confirmed by the seller solicitors and the buyer solicitors, the seller solicitors would usually send the draft contract pack to us. The draft contract pack would include the draft agreement, the contract, which is the draft agreement, protocol documents, such as the property information form, fixtures and fittings form, and other forms as well. If there's any other things, such as if it's a leasehold transaction, if it's a leasehold property, then the leasehold information form. These are the protocol documents which would have various information about the property. Such as in the property information form, you'd expect to see things like what kind of property is it, boundary structures, any disputes with boundaries, any other issues around the property, structural issues, flooding risks, and everything else. Then there's another form, the fixtures and fittings form. Now, the fixtures and fittings form is just for your attention that what is included as a fixture and a fitting within the property. Now, this is for you to agree with the buyer. Sometimes it's already pre-agreed. We as solicitors only look at this form to see if there's any prices mentioned for a fitting or a fixture that's being left in the property, such as a fridge or a freezer. Now, if that's being left at the property, we would see if you would agree to purchase it for such and such amount, or if it's a gift, do you want it? Or do you want the seller to basically get rid of it before completion? Once we have got these documents, and then obviously within the pack, you've got other documents as well, such as the title documents. Now, the title documents would normally include two documents, the title register and the title plan. The title plan would show the exact boundaries of the property as recorded by the land registry. The title register would say that the boundaries edged red in the attached plan so and so is the description of the property. It would say, it would, number one, introduce the description of the property and then go on to say who's the proprietor, any other covenants that you need to adhere to, any restrictions, any charges, like is there a mortgage, an existing mortgage that the seller needs to redeem at the point of completion. Now, so on and so forth. These kind of things would be given in the proprietorship register, title register, charges register. Now, this is for you to just have a look at. We normally raise inquiries, and we would let you know in good time if there's anything adverse. Now, once we have all of these documents in, that is when we'd send you the draft contract pack. Before we do that, I'd just like to make you aware that when you're sending the signed client questionnaire or the client care pack or the engagement letter, as you'd say, you'd have to send us your 6 months of those of bank statements of that account where you hold the funds that you'd be sending us apart from your mortgage. What we're trying to ascertain at this point is, do you have the funds to proceed with this transaction? Now, some firms just stop there and they do their internal checks at that point. Some firms would ask you questions even before the draft contract pack is in, and they'd say, well, where's the money coming from? And they'd do the proof of funds and the source of funds checks. What they're trying to ascertain is there an aspect of money laundering? So I do understand that sometimes the clients may get a bit agitated or annoyed with the questions, the bundle of questions that a solicitor might ask. But as a client, you need to understand as well that us conveyancers and law firms and solicitors have a duty towards the SRA and a legal duty towards our profession to avoid any transactions that have a risk of money laundering. So once money laundering checks are done, obviously, then we come back to the draft contract pack. Now, once we've got the draft contract back, we'd send you the draft contract back for you to review. Normally, within this time, we'd have received the mortgage offer. Once the mortgage offer is in, obviously, that is when we have affirmation that you have been granted a loan by a specific bank. We need to make sure that that letter or that mortgage offer has our name as your solicitors, because essentially the lender is instructing us on that transaction as well. You need to understand that the lender relies on our investigation, as would you, within this purchase transaction. They're essentially our clients as well, because we are representing them within this transaction. Now, once we've got the mortgage offer, we've sent you the draft contract back, we'd wait for your instructions via email to confirm that you're happy for us to order the searches. By that time, you'd have done a level 3 RICS survey done on the property, which would tell you any issues of damp or subsidence or any other things. Just making you aware that the RICS survey, most of it is irrelevant to us because it's got to do with structural integrity and these kind of things. The only section that we're concerned about is the legal. It is a section where it says for your legal advisors or for legal professionals. That is where they'd say, well, you need to look out for these documents, like any warranties, guarantees, building regs, anything else. You need to send us the RICS Level 3 survey if you have any questions with regards to that. But keeping in mind, we'd only be able to help you just with that section where it says for your legal profession, for the legal professionals. Once, obviously, so now we've sent you the draft contract pack, we've got the mortgage offer, and we've got the RICS Level 3 survey. At that point, we'd ask you to review the draft contract pack and see if you're happy for us to order these searches or commission the searches. We can't commission the searches until you have emailed us an authority to commission the searches. This is standard practice within the conveyancing industry, and it is there to save your funds that we hold in our client account, because those are the funds that we used to purchase the search pack, which would include normally 3 searches. Number 1, the local authority search. Number 2, the drainage and water search. And number 3, the environmental search. Now, the local authority search would tell you about if there's any planning permissions, charges, if there's anything adverse in respect to it, which the local authority has recorded. It will also tell us if the roads are adopted or unadopted, or if there's a Section 106 agreement, like a developer's kind of agreements or these kind of agreements. The drainage and water search is only relevant to us if we see on the map of the drainage and water search that the property has been built over a sewer asset. Now, if there's a sewer asset passing through or underneath your property, the building of the property, that is when we require, or the boundary walls of the property, that is when we require normally a build over agreement, or if there is no build over agreement, we'd require an indemnity policy to be put in place by the seller. An indemnity policy is usually a policy that would cover the financial aspect of any breaches that the council may come after you, or the developer or anyone else who's relevant to that transaction or that property would come after you. It won't cover you from the breach itself, but it just cover you with any financial losses. An indemnity policy is a one-off payment, so you don't have to repay it again and again. It's just one-off, and it's payable at the time of completion by the seller. Or if the seller disagrees and says, I don't want to pay for this indemnity policy, that is when we'd come to you and say, well, this is an indemnity that would be required normally. Do you want to, number one, proceed with this transaction? Because in our professional opinion, we think that this indemnity is required. Or number two, do you want to apply for this indemnity yourself? Obviously, if we apply the indemnity on your behalf, which we only have to do ourselves, you can't do it. You can't go to an indemnity provider and say you need an indemnity policy. If we have to do it on your behalf, we obviously would be charging you an additional fee. That is separate to every law firm and every solicitor. It's usually found within the additional fee schedule in our client care documents. And then we look at the environmental search. The environmental search would tell you about if the property is affected by flooding, or if it has a potential contaminated land issue, or it is within a land spill zones, or if there's any issues with contamination. If the environmental search is a failed search, or it's high risk due to a contaminated land issue, or even a potential contaminated land issue, we'd ask for an indemnity policy again from the seller solicitors. If it's high risk in terms of flooding, there's unfortunately no indemnity policy that we can put in place. So we just ask the question, if has this property been subject to higher building insurance policies, or a high rise in building insurance policies? If it's not, the seller would confirm, and that's it. We would, however, let you know of the risks associated with high flooding, but we just making you aware, all of these searches, they're professional opinions by the search providers, and we can't provide you with any further detail. You have to either go to the council or the search providers themselves, or someone who's basically more qualified. Now, that is what the searchers would obviously say. Now, once the searchers are in, that is when we carry out our investigation of title. We review all of the documents that we have, the searches, the draft contract pack, the mortgage offer, your proof of funds, revisit that proof of funds, and just normal compliance checks. We'd raise inquiries at that point. Once inquiries are raised, we send those to the seller's solicitors, and we'd send a copy to you as well, just for your reference. You don't have to take any action. You don't have to be worried about these inquiries. We'd wait for a response from the seller's solicitors. Once the responses are in, we'd send you those responses along with the already sent inquiries so that you can reference them. If you've got any questions or concerns, you let us know at that point. At that point, we'd send you the contract and the transfer for you to sign. Now, normally, we send you 3 documents before we report back to you. And I've had a lot of clients who get worried, or we've not seen the report, you've not reported back to us. Are we creating a legal obligation by signing the transfer document, which is the TR1 document, the contract document, or the mortgage deed? So the simple answer is no. We sent you these documents, the transfer, the contract, and the mortgage deed, if it's a mortgage, if there's a mortgage, to fasten the process, because we need these documents signed and witnessed wherever applicable and posted back to us for us to progress this file further. Now, it does not mean that once you sign these documents, it becomes legally binding. That's not the case. I'll get to that bit in the next couple of minutes, that when does the contract become legally binding on you? When does the purchase become legally binding on you? But just to follow up on that, once you've sent the contract, so we normally send you the contract, the transfer, and the mortgage deed, and we'd instruct you and guide you as to the next steps. How do you have to print off the documents? Where do you have to sign? Sorry, not where do you have to sign, but how do you have to sign? Is there a requirement for a witness to sign as well? Who should a witness be? And then we'd also request for a signed scanned copy before you post the signed wet signatured signed documents to our office address. We normally do that because at the end of the day, at times, I have seen clients signing on at the wrong spots within a contract, a transfer, or a mortgage deed. Just making you aware that if you do not sign in the correct areas of the contract, transfer, or the mortgage deed, you'd have to redo it because the land registry may raise an issue post completion, or the seller's solicitors may raise an issue, or the buyer's solicitors may raise an issue post completion, and you'd have to redo those again, which we do not want anyway. Now, once you've signed those documents, and you've sent a scan to us, normally just give us a call because we might not have had a look at those documents given the sheer volume of the work that we're engaged on a day-to-day basis. Just give us a call and say, well, I've sent the documents to you. Can you just have a look right now? Normally, the conveyancer would have a look right there and then and say, yes, they're perfectly fine to be sent, or no, can you just redo this document and can you just redo it this way? Once you've done that and we receive the documents from you, in that time, obviously we are dealing with inquiries. We'd either be raising additional inquiries or we'd be waiting for all of the inquiries, responses to all of the inquiries. Because it might not be possible for the seller solicitors or the sellers to respond to all inquiries at once. Once all inquiries are satisfied, that is when we prepare the report, prepare the stamp duty land tax return for you. Once that's prepared, we would then send you the report and the stamp duty land tax by email. You do not need to print off these documents or post them back to us. These can be reviewed online and signed via e-signature or just typing your name there and dating the documents. And that's it. If you do not have any questions or concerns with regards to the purchase up till that point, that is when this file is passed to our compliance team. Or the file is checked by a compliance officer at the firm. What this means is they're looking for any issues that have not been addressed, such as proof of funds or anything else, client or matter risks. Now, if that stage is passed as well, the compliance stage is passed as well, and there's no issues identified, that is when this file is ready to where we can agree dates for exchange and we can agree dates for completion. Now, normally we'd email you and say, well, we're ready to proceed to exchange and completion. If you don't have any concerns or questions, please note that we are working towards such and such date. Now, you can communicate to us at that point that this date works for me or it doesn't. Obviously, that date needs to be agreed by the seller solicitors as well after they have confirmed it with their client, which is the seller, who is a seller basically. So, for example, the date is of the 20th, and we are on the 10th. So, from the 10th to the 20th, what happens? Number one, we'd send you a completion statement in which our legal fee and any other disbursements or anything else would be outlined. Because, as you're aware, you do not pay us the legal fee at the very outset of the case. That completion statement, along with a bill, which is solely our fee, would be emailed to you. And you'd have to have a look and see, well, everything's fine. Yes, that's fine, that's fine. Or if you've got any questions, you can just raise them at that point. And that also, within that time, we request for the funds from the lender, and the completion statement would obviously let you know of the funds that are required from you. Whilst you're sending the funds to us, we would normally what is called a certificate of title, a COT. We'd submit that to the lender via our lender portal or by an email to the lender. and then they would approve that the funds will be available to us at this point. Once we have funds from you and from the lender, that is when we can exchange contracts. Now, what is exchange? Basically, exchange is a process for solicitors to get on the phone with each other, and one person recites the contract, the contents of the contract, and the other person confirms that these are identical and they are correct. So both contracts, the buyer's solicitor's contract and the seller's solicitor's contract, should be identical and one and the same. So the buyer solicitors or the seller solicitors will recite the contract, name of the seller, name of the buyer, property address, purchase price, any balance, outstanding, monies held to order, these kind of things, special conditions, and everything else. The deposit that is stated over there, that is a contractual obligation, only obligatory on the buyer once the exchange is happening, not before the exchange. And it's usually 10% of the purchase price. So you don't have to worry about if you're just putting 5% in, or if you're putting, because to us, that 10% is the 10% of the purchase price, not of your deposit. So once we receive funds from the lender and yourselves, the 10% of that, of the total purchase price, is held to the strict order of the seller. It's like a consideration. Now, before we do that, we'd normally call you and confirm by email that we are proceeding to this level, this step, the exchange of contracts. Do you authorize us to do this? Without your authority, we won't be able to exchange contracts. So normally we would read out, we'd ask you some questions about you, about the transaction, so that we can ID yourselves as the buyer. And then you'd give us authority in normal wording. Yeah, I authorize you to proceed with this transaction on my behalf. I authorize you to exchange and complete on my behalf. Once we've had that confirmation from you, we'd normally proceed to exchange. Once exchange is done, then either we can complete, if that's been previously agreed, we can complete on the same day, or we can complete afterwards, some days after exchange. Completion is basically a process where we send the funds to the seller solicitors to their identified and verified bank details. We send these funds across, and once they confirm receipt of these funds, that is when completion has taken place and the estate agents can release the keys, not before that. If there's no estate agents, then obviously it would be an agreement between you and the seller with regards to the arrangement of handing over the keys. Once keys have been handed over, legal completion has taken place. We just confirm by email to you, or just give you a call and say, we have confirmed completion. Can you please collect the keys? And that's it. Now, immediately after completion, we have to submit the stamp duty land tax return for you. It does not matter if it's zero. It does not matter if you're exempt. We still have to submit the return for you to the HMRC. Once that's submitted, then it goes to post-completion work, where we begin the process of registering the property on your behalf. So that is the entire process of conveyancing. In simple terms, I know that it becomes stressful at times, but you need to understand that this process takes time for a reason, so that we can ascertain ownership, we can ascertain any legal issues, and we can report back to you. And then obviously you can identify if you want to proceed with this transaction or if you don't want to proceed with this transaction. Nothing is binding until we have exchanged contracts. So before exchange, if you do not feel like proceeding with this transaction, you can let us know at any point. Thank you so much for watching this video, and I hope this helped. Cheers.